We move from the opening remarks. Our next one is a keynote address by Scott Atkins, President of Insol International. Scott is the President of Insol International and an inaugural Insol Fellow. He is also Chair and Head of Risk Advisory at Norton Rose Fulbright Australia, a partner in the internationally acclaimed financial restructuring and insolvency practice. I guess, Scott, that's where your day job and your bacon comes from, although Insol makes you go all the way around the world. He's repeatedly ranked in global legal directories, most recently by Chambers, as an eminent practitioner. He's the immediate past president of the Australian Restructuring, Insolvency and Turnaround Association and a member of the International Insolvency Institute, or III for short. He's also a fellow of the Australian Academy of Law. Scott's practice straddles the globe, a reflection of his deep eagerness in cross-border insolvency. He has unique experience in advising nations and the governments on insolvency and restructuring law reform, including the systematic and structural reforms required across economies to facilitate and support the effective operation of such laws. Scott has actually drafted landmark new insolvency and corporate rescue laws for Myanmar, which are now in effect. And interestingly, that was the first time I actually met Scott. And I thought it was only about 4 or 5 years ago, but he reminded me it's actually 6 years ago that he first commenced on that project. He's a member of a range of task forces focused on out-of-court workshops, workouts, and insolvency law reform convened by the World Bank and other leading organizations. So, to give his thoughts and his views in this keynote address, can I please warmly welcome Scott Atkins to the stage.
My technology working. Well, Minister Tong, who I appreciate has to go, Justices of the Supreme Court of Singapore, and of course of the International Commercial Court, distinguished guests, ladies and gentlemen. Can I first thank Minister Tong in his absence for the very warm introduction, and of course extend a thank you to Chief Justice Menon for making the court available today for this extraordinary series of discussions, and also for the networking event that will happen after the discussions. At a time of very significant economic and geostrategic challenge across the world, it's really enduring personal and institutional linkages that is going to keep us together and also propel cross-border cooperation and more effective restructuring outcomes both regionally and globally. And so with that in mind, can I begin by thanking everybody for the effort that they've made to be here today, many, of course, in person, some from far and away, and of course those attending online as well. I note the presence as well and the support of our Insol International CEO, Jason Baxter, and of course Head of Asia, who I think most people in this room have met, Claire Wee. Today's discussion, as you've already heard framed by the Minister, provides an opportunity to reflect on Singapore's success in becoming a leading restructuring hub in the Asia-Pacific region, and the discussions that will follow my remarks today will have a look at that more closely. And as we've heard from the Minister, landmark reforms over the past decade have certainly strengthened Singapore's position as an international centre for debt restructuring. And these reforms have included the introduction of the worldwide moratorium provisions, which have been invoked, pre-pack schemes of arrangement, super priority for rescue finance, of course the cross-class cram down to bind dissenting creditors in schemes, and restrictions upon the enforcement of ipso facto clauses. These are innovations, and I do call them innovations when I talk about insolvency reforms, underpin Singapore's prominence as other jurisdictions, such as the UK, the Cayman Islands, Hong Kong and some EU nations, have also undertaken a process to advance their systems. And I will just briefly spotlight some of those developments today. In June 2020, which seems like a while ago, but that's COVID measured time, the UK introduced a new enforcement moratorium and a standalone restructuring plan which includes a cross-class cram down to bind dissenting creditors. And I think the notion of the cross-class cram down, not necessarily first introduced there, has really started to gain attention across the globe. In the Cayman Islands, a new restructuring regime commenced just last month on 31 August 2022. It allows a debtor to seek the appointment of a restructuring officer supported by a worldwide enforcement moratorium and with a view to developing a binding restructuring plan under a refined scheme of arrangement process. As with the UK process, the new restructuring officer regime is available to foreign debtors and is certainly capable of compromising both Cayman Islands and foreign law governed debt. In Hong Kong, and with some fanfare in May 2021, the joint record of meeting with mainland China certainly has now been seen to provide a very useful process for guiding mutual recognition and cooperation in cross-border matters between those two zones. And meanwhile, further north, many nations within the EU are in the final stage of implementing the EU Restructuring Directive, which requires member states to offer a preventive restructuring framework for distressed debtors, as well as incorporating a flexible scheme of arrangement with a broad-based enforcement moratoria and also crammed-down provisions. There's been much interest in the new Dutch scheme and the German stabilisation and restructuring framework. So these developments, and there are many, many more, reflect efforts to create a compelling restructuring system, an ecosystem, that appeals to debtors and creditors alike, serving to restructure complex cross-border financial and corporate arrangements, and also to contribute to long-term financial stability and economic growth. And this trend of continuous reform and innovation across the insolvency and restructuring spectrum certainly accelerated during the pandemic. I think we tracked about 83 different jurisdictions that undertook reform of one form or another, and is very much welcomed by Insol International from a policy perspective. In this global landscape, Singapore, as we've just heard from the Minister, is again leading the charge, and it's the SICC, as we've heard, that will play a key part in further expanding Singapore's restructuring ecosystem and advancing its position as a restructuring hub. The SICC, as we've heard, has had express jurisdiction to hear cross-border insolvency cases now for just over a year, since August 2021, and this capacity will be further enhanced now with the arrival of Judge Sonchi. Judge Sonchi, as we have heard from the Minister, brings 16 years of experience as a US bankruptcy judge, and his recent appointment, I think, strengthens the institutional framework that has been founded here, and also over time will increase, I think, Singapore's appeal as a restructuring hub. The amended SICC rules, and maybe there was some overnight reading of those rules, further extends the court's processes to proceedings relating to corporate insolvency, restructuring or dissolution that are international and commercial in nature. So I know that many of you will have a close look at the rules and unpack them. They enable the SICC to make orders for substantive relief in insolvency situations where a foreign company has a substantial connection with Singapore, and this is a topic I think we'll explore in the panel discussion this afternoon. The court has a very broad discretion under the amended rules to adopt practices and procedures that it sees fit to make orders which are likely to secure substantial justice. So in that sense, and with that broad, flexible framework, the SICC has a real capacity to make sure that it can deliver creative, forward-thinking restructuring outcomes. A lot of that will be fueled by the practitioners and their creativity. And this, I'm sure, will appeal to debtors and to creditors in selecting an optimal restructuring forum depending upon the circumstances of the particular situation. Certainly the flexibility and hands-on commercial nature of the rules will help to save time and cost, and we know that they're often the enemies in restructuring, and they're critical factors whenever value maximisation is under the spotlight, which is every single time we have an insolvency. There's another part which is the continued active case management powers under the rules, and these include the ability of the court to order mediation and other ADR processes. So this sets the scene for the SICC to further champion the use of ADR as a restructuring tool in guiding creditors toward consensus, and there'll be discussion later about this in a number of different ways. In addition to the amended rules that have been showcased so far, there was also a new amended legal professional rule, other than the one touched on by the Minister. These rules are intended to facilitate the participation of foreign lawyers to appear before the SICC in insolvency, restructuring and dissolution matters concerning offshore issues. So this will help to continue build the restructuring ecosystem of the experienced professionals who are coming from other jurisdictions and who will help Singapore build out its restructuring hub, working of course in tandem with local practitioners deeply steeped in the cases and the local traditions and the legal system here, and also to help the judges of the SICC navigate complex cross-border situations and deliver that institutional capacity that will drive commercial and in many cases creative restructuring outcomes. So if I may say, what Singapore started 6 years ago was certainly visionary. Some would say it was perfectly timed. There's that old expression that the best time to plant a tree was yesterday. And this embodies, if I were to quote from somebody, Theodore Roosevelt's idea that the one characteristic more essential than any other is foresight, and it should be the growing nation with a future which takes the long look ahead. And I think that's what we see here with the insolvency reforms that have been the subject of discussion. If we look in another direction, and that's forward, I think Singapore's position probably has some additional significance at the very present time. We're all well aware we're in a very difficult economic period, not just locally, regionally, but indeed globally. We've seen global stagflation. We all know about ongoing supply chain weaknesses. There's a food crisis. There are energy insecurity issues. And of course, the world economic outlook is grim, and the IMF has forecast that baseline GDP, of course, will continue to trend downwards, certainly for the remainder of 2022, and we'll see growth levels as so low that we haven't seen such statistics since 1970. Tighter global financial conditions, as we all know, will lead to debt distress, especially in emerging markets, and the intensifying geopolitical tensions which have really defined the contemporary era will continue, and of course we'll see greater fragmentation in global trade, investment and financial systems. It all sounds a bit doom and gloom. There'll also be further pressure on business in the global transition toward a net zero emissions economy, and climate finance to assist in this process has certainly been rostered to be top of the agenda for COP27 when the UN Climate Summit meets in Egypt in November. And then on a micro level, of course, while many businesses have emerged from the pandemic with a substantial debt overhang, there's no doubt that their increased leverage ratios and the possibility of default risk is increasing, and government support mechanisms are certainly being wound back across the globe. So I'm not in a position to predict whether the long-awaited avalanche in insolvency filings is going to materialise or not. I think we all spend a lot of time looking into that crystal ball. But if you look at the data in some jurisdictions, it's certainly the case that insolvency filings are starting to trend toward their pre-pandemic levels. And I think I'll invite the panel to explore that topic and give a survey or an assessment of what's happening across the globe as we get underway. So these major economic events and the macro transitional trends and the financial downturn that I've been talking about tend to be the catalysts for novel restructuring outcomes. They will transform perhaps further the restructuring and insolvency landscape, and perhaps forge even more new and different principles that will shape the way that we practice in the era ahead. And flagged already is the extraordinary change that's coming driven by cryptocurrency, the crypto winter, in which we've seen global crypto assets already deteriorate by something in the order of $2 trillion since its peak in 2021. So expectedly, the rate of crypto insolvencies indeed has increased, and we've heard of the collapse of crypto lenders such as Zipmax, Vald and Holdenort, and these have already been the subject, of course, of moratorium protection in Singapore, and in the case of Three Arrows Capital, the liquidators in the BVI last month were given authority to access the company's financial records and assets held in Singapore. So already, in a very short space of time, we're starting to see the catalytic effect of crypto collapses bringing new considerations, and certainly at some point asset tracing considerations into the domain of restructuring and insolvency. So this has also brought, I think, into sharp focus some unresolved challenges in how practitioners can adapt to new technologies, new classes of asset, and certainly effectively trace and secure and recover assets with the assistance of the court. And this is certainly one of the areas that we've spoken broadly about, because not only will practitioners need to increase their capability and capacity to respond to crypto issues, but so too will courts and other aspects of institutions generally across the market. There's another aspect I'd like to touch on briefly, and that is the amount of new, very novel insolvency filings arising from the commercialisation of outer space. And when you look at the data in relation to outer space, some of the numbers are quite remarkable. There's an investment rate of about US 350 billion per annum in outer space, so it's no longer confined just to state-sponsored activities. Morgan Stanley estimates extraordinarily that by 2040, the global space industry will generate revenue of more than US dollars 1 trillion per annum. Yet when we look at the commercial space industry, it's made up by a significant proportion of startup enterprises and a high-risk, high-return investment culture, as well as activities that are inherently speculative in nature. And we all follow the news every time something is launched, and of course we know sometimes it isn't launched. So in these economic conditions of the challenging type I've been talking about, we're now expecting to see an increased number of insolvency filings for commercial space enterprises. Already we've seen Intelsat, OneWeb and Speedcast, and so courts, I believe, are going to increasingly become the forum for resolving complicated multi-party claims, despite there being currently a void of outer space regulations and standards. So if I were to make any suggestion humbly at all, it might be that the SICC rules in the next iteration could be extended to cover the atmosphere as well. Someone really needs to help us deal with outer space. So in addition to dealing with this enhanced complexity in insolvency matters on a substantive level, and we've heard of the era of hyper-complex disputes, as Chief Justice Menon has said, courts are going to need to grapple with challenges on a procedural level in cross-border recognition, cooperation and harmonisation. I personally don't buy into the notion of a retreat from globalisation in business. So the model law, which we've celebrated the 25th anniversary of earlier this year, has certainly, as we all know, helped to centralise insolvency proceedings. It's reduced the cost, it's certainly enabled us to avoid, in many cases, the prospect of inconsistent judgments. And of course, creditor disputes and piecemeal breakup of debtors' businesses have been minimised in many cases because of the extreme efficiency of the model law. Singapore, of course, has been a leader in adopting a broad, flexible interpretation of the model law, and has kept up with the very universalist approach which Insol encourages, and so we get more effective restructuring outcomes. In a judgment delivered a week ago, Justice Abdullah reinforced in Ram's challenge shipping that provided a foreign restructuring process can be seen to operate within the broad, proper purview of an insolvency or restructuring effort, then difference in the modalities or the detailed scope of restructuring laws across jurisdictions should not prevent recognition, and certainly not prevent recognition being granted under the model law. In that case, it was a corporate reorganisation in Japan. So this broad-based universalist approach is certainly at the heart of the model law framework, as everyone in this room and online is aware, and it's what will continue to drive very successful commercial restructuring outcomes as we continue to navigate our way through an interconnected modern global economy. That said, though, effective restructuring outcomes and consistent and predictable results for creditors depend upon the adoption of the model law and its implementation well beyond the 53 countries that have done so to date. It's also going to be very important to consider adoption of the two other model laws, the model law on the recognition and enforcement of insolvency-related judgments and the model law on enterprise group insolvency. Chief Justice Menon noted in his remarks at the III in 2018 that model laws are powerful instruments for driving legal convergence in areas where states may have significant defensive interests. So if we look locally in Singapore, the existing model law has already been given a very broad interpretation, and this was reflected in re Tantalef in the Supreme Court in June, so as to permit recognition of not only a foreign restructuring proceeding, but also an insolvency-related judgment, in that case concerning a foreign restructuring plan. So this expansive and universalist approach, which I believe is certainly consistent with what's favoured in the United States, but I'll defer to the US practitioners here, is ultimately what's needed to ensure that a cross-border restructuring process can be carried into effect across multiple jurisdictions. It's certainly the outcome which the new model law on the recognition and enforcement of insolvency judgments seeks to achieve on a more uniform basis. So certainly from an insol perspective, we would advocate for the adoption of that model law. Meanwhile, the model law on group enterprise insolvency increases the potential for group restructuring arrangements, certainly to be negotiated and executed in multiple jurisdictions simultaneously. And the model within that law is to try to do so under a guided framework which has a concentration of insolvency proceedings. This is, I think, especially important if we look at the cycle that we're about to go through and we realise that many of the organisations that may end up using the process are likely to be genuinely multi-jurisdictional in the way that the business is operating and the way that corporate group structures have been established. Neither of these model laws have been adopted in any jurisdiction to date, although they've been around now for a little bit of time. And perhaps it's the case that neither are necessarily perfect. But certainly the UK government is now well underway with a consultation process to consider the adoption of both of those model laws. And I think what we've seen historically is that if the UK adopts those model laws as it's expected to do, then this will be a spark for other countries to do so as well. This is certainly an outcome which INSOL, UNCITRAL and the World Bank advocate for, and we certainly continue to prioritise in the work that we do in capacity building initiatives, in judicial roundtables, in training that we undertake, such as training that we undertook this morning, as well as collaborative engagement with regulators and policymakers. So there is a substantial push behind the adoption of these model laws. I won't go on about them too much. I think we'll leave it to see how the UK consultation process unfolds and what happens after that. If I can turn briefly then to the SICC on an institutional level, there is incredible capacity here with the judiciary, within the Supreme Court, of course, and also with the 18 international judges. And with that capacity and Singapore's quite advanced insolvency ecosystem, I think there's the potential for the SICC to realise Justice Ramesh's vision, which is for greater weight to be afforded to party autonomy and good forum shopping in cross-border insolvency matters. And we might talk a little bit later about that. This notion is a concept that debtors ought to be able to select the nodal jurisdiction with the right DNA or the right ecosystem to achieve good restructuring outcomes. So this is very much with a view to trying to ensure that the sort of loaded language of bad forum shopping is put to one side, but rather optimal outcomes are explored and designed to help debtors get through a restructuring process. So for Singapore to continue to build its reputation in this regard, though, as one of those nodal jurisdictions, it is critical that the entire restructuring ecosystem must continue to expand and to improve its capability, not just in Singapore, but across the region and indeed globally. So from an INSOL perspective, we continue to focus on capacity building initiatives that are so critical to try and strengthen partnerships, strengthen relationships across stakeholders, and certainly, wherever possible, to undertake training and capacity building to talk about the very issues that we've already traversed today. Locally, the joint SMU IPAS graduate certificate in insolvency and restructuring is an initiative in that regard, and that course welcomed its inaugural intake in March this year, and it's a very important part of enhancing the regional restructuring ecosystem. And INSOL is very proud to have been able to contribute to the development of that particular course. And INSOL's Asia Hub, I've mentioned Claire is here today leading the hub, Insol's Asia Hub continues to prioritise collaborative engagement throughout the region. And while our globally recognised training and education programs are on offer broadly, some are bespoke for the Asia Pacific region, there's no question that the feedback that we keep receiving is that these will help equip current and future leaders in the profession with the knowledge, the experience and the practical skills that they need to be able to contribute to the global restructuring community. Given its grounding in the resolution of complex commercial disputes, the other unique characteristic of the SICC, I think, is to propel forward the intersection and consideration of the intersection between insolvency and mediation. I think for many in the room and online, we know that a mediator can help creditors negotiate a reorganisation plan and to resolve narrow substantive disputes, or to at least resolve and narrow substantive disputes. And as Justice Ramesh noted in his decision in Re I.M. Scorgan, a mediator can play the invaluable role of building consensus and trust and can assist to iron out the wrinkles and creases that frequently erupt in a restructuring, which are perhaps not best resolved in the adversarial cauldron of the court. And I'm sure some have observed that, but I'm sure not too often. So Singapore, of course, over a number of years has actively sought to promote mediation as a viable restructuring tool. It's already being very heavily deployed, of course, in the United States, and we've seen court mediations there in very high-profile matters, most recently in the so-called Texas two-step, and that may come up in discussion today. Insol's ADR colloquium, which was launched in London at its June conference, strongly advocates for mediation in bankruptcy situations. Insol certainly sees mediation as providing the very necessary flexibility to extend multi-party rather than purely bilateral disputes, and it empowers debtors and creditors to try to come up with better outcomes facilitated by agreement or by steps to get toward agreement, rather than just working through the constraints of traditional and formal legal processes and formal insolvency rules. Further uptake of mediation could, of course, be encouraged through the greater adoption and implementation of the Singapore Convention on Mediation, and that has been around, as we all know, for 2 years. As a framework, it presents an extraordinary opportunity for both the recognition and the enforcement of agreements that are entered into through a mediation process. But certainly, again, it's a particular system that could be embraced more broadly. So in short, if we look at the intersection between insolvency and restructuring and mediation, we would advocate that in every instance now, when reform is being considered, and it certainly is across many jurisdictions currently, that the role and the opportunity of mediation is looked at very carefully as a critical piece of any restructuring hub or process. So in concluding, can I just reflect on Singapore's very bold vision to become a world-leading restructuring hub when its law reform process began more than a decade ago now. I think with its enhanced insolvency-specific jurisdiction and its expert insolvency and restructuring judges and practitioners, as we've heard today, the SICC will, I believe, help Singapore to further enhance its appeal as a restructuring hub. And collectively, the many global developments and the trends that we're all observing and we all have our own views about and the intensity of them, I think are going to ultimately and very quickly deliver us some cross-border insolvency and restructuring outcomes. So we'll start to see some activity in the space at a greater velocity than we might have had over the recent years. So with that, can I thank you very much for coming today, for those who have joined online, for engaging in the discussion, and I look forward to the unfolding of that discussion through the course of the afternoon. Thank you.